those of you who are on the call this morning, if you could please shoot me an email. I sent you all the Zoom link yesterday. If you could please respond to that email, just saying, yes, I'm on. So we have a sign-in sheet here at ABC for the people that are attending in person. So for those of you that are on the Zoom link, if you could go ahead and shoot me an email, so I'll mark you off as attending, that would be great. Are you somebody for somebody's spot? Are you down the street from us?
Yes, that's fine.
Hi, nice to meet you.
Sam
Has nobody from Sophia's? That's fine.
Okay.
Okay.
And when I retire in 7 years, she's literally taking my job. So
I was gonna say, is she your protege?
and I keep less than that. Sometimes it's 3 years, sometimes it's 7 years, sometimes it's 9 years.
Plenty of room on the far side.
Sometimes it's 3 months. I don't know.
I haven't pulled that one out yet.
The lowest it's been 3 years.
Okay. Yes, yeah. No, yes, there's another half of the building that's, it used to be, what's called Farm America, which is like.
We had a question yesterday from someone who has employees in the state of Delaware, but the company is a Maryland-based company. I don't know if the person is on the call today or not, but there might be some questions about the state employees that have employees here in Delaware, and whether or not they have to be involved
They're a
in this.
Maryland company.
Do you know anything about that? Is there anything in that statute?
They're not in Delaware, Maryland, but they have employees that work in Delaware, so they're gonna have to follow this. Very good question. Well, why? They're not a Delaware company. But they have to. They don't know exclusively. That's a good question.
If you haven't signed in, there is a sign-in sheet here up at the front of the room, please.
I think I'm overhearing a conversation about whether Maryland, if a Maryland company has Delaware employees, whether it does apply, whether this new act applies to that company. And I would say the way it's written, then it does. It's any company that has the primarily, its employees that are primarily located in Delaware, it would apply.
Okay, that was me, and it wasn't, yeah, it was a question right for you, it wasn't. So, okay, perfect.
And what if they just have a little loop?
Go ahead. Yeah. Okay.
Hi, I wanted to know if you guys could check my car. I have an oil leak.
So that would be something that my master tech would need to take a look at, and he doesn't come back in.
Okay, tomorrow can I do an appointment?
Definitely bring it in and drop it off with us for a couple hours. And
Delaware
Thank
is.
you.
Yes, Maryland. What if they're only working 3 or 4 days in Delaware?
Okay.
If they have an employee that works 4 days in a year in Delaware, I can see that coming up as a problem.
right on time.
I can address that too. I can hear what you're saying about who's working in Delaware and whether it applies. Do you want me to speak to that already? Just go ahead.
Not yet, but that was. a
Okay.
question that came up, and I don't know if it's from someone who's here who's going to be on today. Or whether
Okay.
it's all in the office, but if you could address that throughout the presentation, that would be great. Yeah.
Yeah, absolutely. Once everyone gets there, absolutely. Yep.
Good morning, everybody. If you haven't signed in already, if you could sign in, the sign-in sheet's over here. That would be great. We will go ahead and get started. Good morning and welcome. It's August. Yay! And I know the parents are like on that downhill slope to getting the kids back to school. Those of us without kids are like, oh my gosh, I only have a month left to do anything. So we got both people going on. So welcome to our seminar this morning about the Delaware's FMLA rules and regulations and the havoc it's going to create for you as business owners and as well as your employees, who are probably going to have a lot more questions as things come up that we never thought of in the very beginning. So we are glad to have with us this morning Maria from BHI and Catherine. Wave, Catherine.
Hi, everyone. Hi.
Kurman, one of our law firms here in Delaware and a good ABC member, to walk you through things that you're going to need to know. So we do have people on Zoom. I have muted you all. Please, if you have any questions, when the time comes, unmute yourself. But during the presentation, we ask everybody who's on Zoom to please keep themselves muted because I'm sure there'll be some extraneous conversations going on. It's so distracting here in the classroom. So without further ado, Maria and Catherine.
Awesome. Thank you. Thanks, everyone. It's so good to see everyone in person. I was just saying, like, it's just a breath of fresh air. So it's very nice to be here. As Jean said, my name is Maria Clyde. I do, hold on 1 second. Okay, we're good. So I do benefits. I'm a benefits broker, HR consultant for BHI. And also with us, we have Catherine. Catherine, I'll let you go ahead and introduce yourself.
Hi, everybody. Yeah, I'm here, the woman on the screen. I wasn't clear if we were able to do it in person, so I apologize. I didn't know that we could do it in person, believe it or not, after all this like craziness, right? So here I am, at least I'm here virtually, happy to answer any questions. Please, get in touch after the presentation if you need something, but very briefly, I'm a principal at Offit Kurman. We've been members for many years. Some of you probably know my partner, Kevin Fasick. But it's pleasure to be here. I'm an employment specialist, so anything you need in that realm, feel free to give me a call.
Okay, so I'm gonna try to do this. All right, I'll just move this around so we can make sure that we see. I want to just preface, go ahead.
Can I email the presentation to all the?
Absolutely, yes, yes. So what I want to just kind of say, and if any of you have been to any of my presentations, I like to keep a more casual type of discussion based rather than a presentation and Catherine and me talking at you, because especially for this bill, there's a ton of questions still left for this. So that's a disclaimer. If you think you're going to walk away knowing every single thing and everything's going to be black and white, unfortunately, that's not the case. It's just the nature of this bill. It's the nature of where we're at with this. So what I did for you with this presentation, and Catherine, of course, from the legal perspective, is going to kind of help me break down the law. I went through the 17 to 20 pages PDF of the actual law, breaking down exactly what we need to know. The number of employees that we need to be concerned about. What does it mean for us as an employer? What does it mean for our employees? How to handle abuse, all of these types of things. And I know that there's going to be some questions that come about, like I know there was already another one about Maryland and reciprocity and all that type of stuff, because I know a lot of us in this room have employees that work in Maryland as well. Have employees that primarily, which is what the bill says, work in Delaware. And then I also just want to call attention to the fact that there's a lot of other neighbor states. So New Jersey, New York, Massachusetts, not exactly a neighbor, but in this general vicinity that also do this. So I always say that if it's already in the surrounding states, guess what's coming to Delaware? So we'll want to just kind of take a look at what they do and the differences and how they use a state fund or don't use a state fund. So Catherine, is there any other kind of disclaimers that we wanted to talk about with this?
Yes.
No.
Hello?
Yes.
I'm still waiting for an available representative on the other line.
I'm going to ask everyone please to be on mute just so we don't have the distractions.
Right, Maria, I think that you're absolutely right on. We are not going to answer all the questions now. There are going to be questions even as this law is implemented, because some of the language isn't clear. They don't always consult attorneys in the House of Representatives when they are the Senate, when they're introducing bills. And so they leave things, unenforceably vague sometimes. And so people are just going to say, well, what does it mean primarily in Delaware? What does it mean, for the previous 12 months? I've spotted some issues, right? So we can look to case law in the other states that have already passed this legislation, as you mentioned. They're very, very similar. But we won't know anything until Delaware courts opine on it, or there are really, really clear regulations issued, which there are supposed to be. Crossing fingers, supposed to be.
And Catherine, do you know anything about when when they're gonna, maybe answer a lot of the questions or open it up for questions or comments?
I would say not until 2023 at the earliest. They take their sweet time with this stuff, but luckily we have a long time to prepare for it. So we should be in good shape. What I really hate is when Congress or our legislature passes things and then says, oh yeah, we'll regulate it. And it's effective immediately and you have no clue. You have no clue what's really happening. So that's not here. We'll be good.
Yep, so July 1st was when it was signed and official, but luckily for us, we don't, I believe the payout of the fund doesn't start until 2025, which we'll talk about, but one of the other provisions, and this is the reason why I want to get this discussion starting now, is that in order to waive out of the state fund with a private plan, you have to do that by January 1st, 2024. So with how fast this year is going, that's why I want to start this discussion now, because you all as business owners, as HR people need to, we need to give you the information to help you decide whether or not you want to do a private plan. And we hope to kind of walk through a lot of that today after we break this bill down. And did you have a question?
So that's separate from the state. The state's plan, the private plan would be
Yes, the private plan would be something administered through your
company only?
Yes, correct. And that's what I want to talk to you about. And obviously I have kind of an interesting perspective of that being on the benefits brokerage side and how that could work with the private plans and the carriers. And then I actually have some clients and some folks that I've talked to who self-administer disability period. So that is an option, but there are certain ways, and I know that's risky in my opinion. It is risky because there's some compliance and liability there, but there's a couple of options here, and we want to make sure that we can kind of talk through. Okay, what are the options here? How are we gonna? At least you'll have a year to figure out which option might be best.
Somebody's going to regulate it no matter what.
Correct. Yes, and there isn't much to it yet, Catherine. I know in the bill, it sort of breaks down, hey, if you want to waive out of the state fund, you have to do so, and you have to submit everything, and you have to meet all of this criteria, but we haven't yet figured out yet whether it's, do we send them just a certificate of insurance of our existing, like let's say we have a MetLife policy, a principal policy, what is that going to look like? And the other thing you have to keep in mind is a lot of the general kind of disability policies that we're working with right now are just that, employee disability policies. So this particular law, being that it's FMLA, it's Family and Medical Leave Act, we're going to have to make some changes with the policies. There's going to have to be riders, there's going to have to be addendums to that, because it's not, people can be out for any reason, not just their own medical condition. And that's the biggest difference between what we have on a short-term disability that a lot of us are familiar with. Oh yeah, we provide company paid short-term disability for our employees. A lot of companies do. But how do we get that to be compliant with the state? And that's what we're going to talk through and break through today. Sound good? Okay. All right. Okay, so just kind of general things. Title 19 of the Delaware Code, that's what we're working with here. This is Family and Medical Leave Insurance Program is what they're calling it. Delaware Healthy Families Act. And generally, so for, I guess, quick show of hands, how many people in the room have more than 50 employees? So are already FMLA eligible? Okay, so a good portion. So same FMLA employee eligibility requirements, which is a good thing. Means the employee has to be with you for 12 months. They can't come in on first week or first month and say, hey, I'm having a baby next week, or I'm going out and I have a parent or a child or whatever that's sick. So they have to be with you for 12 months. So that's a good thing. The other good part of this too is the 1,250 hour working hour requirement. So they must have that many hours of service in that year prior, which for a lot of us already kind of eliminates our part-time workforce. So again, that's a good thing that We don't have the part-time employees now to worry about coming in asking to be off for FMLA reasons. Now, Catherine, not to get into like the Maryland stuff, but one of the things that I want to call out, this is coming to Maryland. It's coming to Maryland, I believe, effective October 1st, 2023 is when I think the contributions start. So if you have employees in Maryland, we could do a whole other separate topic on that. We're not going to focus that much on that today. But what I want to call attention to for Maryland is their hour eligibility threshold is something like, I think it's 680 hours.
That's wrong.
So that's half. And that's gonna lump in a lot of our part-time employees. I have to do the math, but it's something like an
So
average
does
of
that,
24.
if you have part-time employees that are under the 1250, are they not included in your employee count?
They are still included in your employee count,
Okay,
yes, but they are not considered eligible,
okay.
yes.
Included as a partial of your employee count, correct?
They are, so for this, and Catherine, I'm gonna let you confirm this, but I'm pretty sure that even though they're still part-time, they're considered as one, correct?
I'm not sure honestly if this is directed to full-time equivalent employees or whether the count is for part-time employees, to be honest with you. So for instance, you could have 2 part-time employees and their time equals a full-time employee, then that would be one full-time equivalent, right? But we honestly, that's not addressed. It's one of those great questions that isn't quite spelled out. If I had to guess, I'd say the legislature intended to include part-time employees in the count, but I wasn't there. I didn't hear the addresses on the floor. So
Because that's only 24 hours a week,
The
1250. And 600 would be what, half that? 12 hours a week.
1250.
1,250 hours in a year, yeah, divided by 52, so 680. Talking 13, yes.
13 hours a week.
Yeah. So do we have, and that's a good question, do we have people in here for part-time? Are we coding that as 20? For 20, that's good. Anyway, things to think about, yes. So this is great. And this is why, again, I wanted this to be more of a discussion because we're going to start thinking of things. And my intention of this is to go back when they do open this up for questions, because I've done this before with other organizations, DCA, and I plan to continue to do this, to kind of collect all of these questions of things that we're thinking about as people who are going to have to administer this. That's the issue, that every single one of us in this room are going to be affected by administering this, communicating this to our employees somehow, and figuring out what the heck. I just want to clarify real quick, the full-time equivalent. I can just go over that real quick if we're not familiar, but full-time equivalent, meaning from a benefits perspective, usually when we have 2 part-time employees, technically they're 2 different individuals, but they count as 1 full-time equivalent. So that's something that is a good question that we'll want to make sure that we clarify there. And then,
But how would you choose then who would get the benefit if you have 2 different employees included as one?
so we're just talking about them being counted as
An
one
employee.
employee. Correct,
Okay.
yes. Yep, but that can get
Right.
confusing sometimes.
right, they'd both be entitled, right? If they'd worked 1,250 hours a year in the last 12 months, yeah.
Yeah. So anyway, and that's another thing that we'll want to talk about. So on the part-time, full-time basis, how we're classifying our employees, that might be a change that we want to make in our classifications. A lot of folks have gone with the ACA standard that anybody who works 30 hours and above is considered full-time. Anybody who works below that is considered part-time, but now this is something that you'll want to take into consideration. Are we saying part-time at 20? Are we saying part-time at 24? What is this going to look like? All right, so here's the other one. Employees primarily reporting to work in Delaware. and Catherine kind of alluded to this. Catherine, I'm gonna let you talk about this. What does primarily mean? We don't know, is the short answer, right?
That's a great question. Yeah, that is another long question, long answer. But I mean, I'd have to say they mean the majority of the time, over the majority of time, right? If it's more than 50% would be reporting to work in Delaware, but I don't know how high the regulations will say that has to be. You know, it might be 75% reporting to work in Delaware. And interestingly, this does not exempt companies who are incorporated in other states, who mainly do business in other states. Say they're Maryland, say they're PA, say they're New Jersey. Are those employees, if they primarily report to work in Delaware, covered? Yes, they are. But with Maryland, you're going to have your own system there, and anyhow, right? You're going to be, unfortunately, I hope they're not too different. It looks like there are some differences, like Maria mentioned, with the number of hours that have to be worked. But so a Maryland company would already be thinking about that for their Maryland employees, and for their Delaware employees, it's really no different. I hope that makes sense. Anybody have a follow-up question on that? Okay.
I think one of the biggest things and one of the takeaways and action items, and that's what I'm going to try and do after we talk about these gray areas is, okay, what do we do now with this? How are we gonna prepare for this? I think we should start tracking now for any of your multi-state employees. Let's start tracking now how much, what's their hour, is it 50, whether you want to do percentage or actual hours worked. Let's start tracking now how many hours worked in Delaware, how many hours worked in Maryland, because in reading the bill, they mention in here that they're gonna look at the previous 12 months and kind of classify, correct, Catherine? That's how they word it in the bill, right?
It is, right. I should add that for if somebody's reporting out of state on a temporary basis, they can be labeled as ineligible for that time period. Say you have an employee that's doing only work in, New Jersey for, a period of time, 6 months or something like that. They can be deemed ineligible for that period of time, to make it even more complicated, but that is what the act says.
Right. So with that being in mind, there's also, now they make it even more complicated, and it's not just everybody is subject to this. There's different levels of this. So 0 to 9, if you have 0 to 9 employees, then you're fully exempt from having to comply with this. So you don't have to worry about it. You have 9 employees or below. Okay, great. You can leave. No. Okay. All right. So for 10 to 24 employees, you just are subject to the parental leave provision of this, meaning that if someone has a child, and again, that's has a child, adopts a child, or is a new parent in some way, shape, or form, you have to abide by this. Anyone who has 25 or more employees, you're subject to all of it, meaning you're subject to provide the parental leave, the family caregiving leave, and then also the medical leave as well, which we'll get into kind of the details, but that's what you're talking about, serious health conditions for yourself or family members, etc. So kind of basic, pretty basic for that. I'm gonna pull up the chat here. What if work from home? Yeah, so that's another thing. Helen, just to address that. It is, if they are working from home, that is deemed their work state and work location, right, Catherine? What are you seeing on this whole remote work?
Yep, absolutely. And I just actually answered that in the chat because it popped up and you were speaking, so I just put that in there. Yeah, with all these remote workers, we need to make sure our employers are understanding that the laws of the state in which they're sitting, performing that work, are the employment laws that are going to apply to them. So for instance, make sure that if you've got someone who's now working for your company sitting at a computer in North Carolina, you are observing those North Carolina laws. Number one, for certain, with all the other states, all of their states require that you notify the employee of the laws of that state. So number one, say you have someone in North Carolina and you're just starting out with this whole thing, send them the notice immediately, email it, right? The posters, as they call them, the notices are available on the Department of Labor website for each state. So cover that first, then you can check the poster and see if you're complying with the laws that you just notified the employees.
Yep, and we'll talk about the notice requirements in a little bit, but this is just a graphic. Again, this is the same thing that I listed in the presentation, and we'll send you all this information in the presentation. Like I said, I just broke the law down, took the highlights out of the law, put it in a presentation for you. And again, I like this graphic. The other reason, which we'll talk about, is military leave as well. So that's something else that's going to get looped into this. Again, that's also on federal FMLA. So for folks who are already used to the provisions of federal FMLA, that's no surprise there. So again, I'll move this around here. So 3 different types of leave. Like we said, parental, family caregiving, parent, child, or spouse with a serious health condition, medical, the employee's serious health condition, and unable to perform the essential functions of their job duties. So this is very similar to what we're used to today under the ADA and reasonable accommodation, or regular FMLA. If someone's going out and saying, hey, listen, my doctor has advised that I take a leave of absence from work, I have a serious health condition. I always recommend when we're looking at this, we gotta have job descriptions. I know putting together job descriptions, I know I'm in HR, are like watching paint dry, right? It's like watching paint dry, doing handbooks and doing job descriptions. However, these types of things are very, very important for situations like this. You have someone who gets hurt, someone who has a serious health condition and is coming to you and asking for a leave of absence or to be reasonably accommodated. What does unable to perform the functions of their positions? The only way really it's clear is if we have physical requirements clearly listed on a job description, operating a company vehicle, maintaining a CDL license, all of these types of things. Catherine, I'm sure you've seen things like this pop up, but just this is my crusadership for please everybody have good job descriptions because they come in handy for instances like this where we have to document this type of stuff.
They certainly would come in handy. I would caution you though to make sure that the job description matches what the person's actually doing. Sometimes people write a job description 6 months before that something like this comes up, and then they have, in the meantime, the person has changed, they're no longer operating a vehicle or what have you. Then you want to make sure when you're looking at the assessment of whether they're able to perform the functions or not, is that really what they're doing? So yes, job description, yes, and update, yes.
And then speaking to what this term, this like catch-all term, qualifying, it's exigency, right? I always have trouble saying that word. So, and that's under federal FMLA, right, Catherine?
That's right. It's defined the same way. And it's, someone's deploying someone, there's some definitions in the FMLA. If you want to contact me, I can provide you with the definitions of these terms. For those of you who aren't familiar with the federal FMLA.
How do you define serious?
Right.
Catherine.
Yeah. Serious health condition is again defined by FMLA. So if you want to contact me again, I will give you the definition of that. But it's something more than a passing condition, right? It's not a broken foot. You don't have to give someone accommodations for a broken foot. You also don't have to let them take leave for a broken foot. It's a passing condition, right? Do you give someone 2 weeks off? Maybe you do anyway, because you're just a nice person and they can't do what they're supposed to do with a broken foot. However, I think it's more like an Americans with Disabilities Act definition, which is something that lasts, something that persists. It could be aware that it can be something like cancer though, because cancer is something that could recur and could be recurring, could be a continuous condition. Whereas, like I said, a broken foot would not be that. A sprained ankle would not be that.
And then that's where there's a whole, we're not gonna get into the federal FMLA, but there's a whole host of resources and forms from federal FMLA that the employee takes this form to their doctor to confirm the serious health condition. And the doctor is the one that's weighing in, right, Catherine? The doctor is the one that's deeming this chronic, serious, and then my thought is always, again, having that job description to see, okay, hey, doctor, this is what my job descriptions are, this is my physical requirements. Can I perform these essential functions? And having the doctor be the one who makes that decision. That protects
Right.
us as a company.
Right, exactly. And if you disagree with the doctor's opinion and you think someone is faking it, well, then you can get another opinion. You can actually pick your own physician and have another opinion weighing in.
Yep, and, the Delaware law does actually state that too, that if there's this whole process, I know reading these laws can be challenging, but do read through it. Take some time and read through and highlight it, because it's just gonna have to be helpful. The language isn't too bad. It reads okay, but then you can kind of see some of these where they go down the rabbit hole for this of oh, you can ask for a second opinion, and then they kind of go through all these details of what to do with abuse and all these types of things. And then, of course, contact your employment attorney as well, right, Catherine?
It's always better. Let me just say, some people have tried to claim that the person is terminated for FMLA fraud, as they term it, right? So I've seen those cases. And, for instance, someone's out and there's this case where someone is out on, because they have really bad back condition. And then another employee spots them at a beer garden, at a festival, and reports to the employer that they've seen this guy walking around. And the employer goes, let's FMLA fraud, right? We're letting him go because he's pretending this isn't real. He's out at a beer garden, right? At a festival. So unfortunately for them, what they should have done is ask for another medical opinion. Okay, but they did not. They decided to just say, well, he's fired for fraud, right? Because he's pretending. What you really, really want to do is get another doctor's opinion. And that opinion can be, no, he shouldn't be walking around. That's inconsistent with what he's claiming. Or it could be, the guy was up on his feet for a couple of hours. There's nothing really wrong with that.
There's the famous case, isn't it a Taylor Swift concert? There was somebody who, that's a famous one. And then of course with social media and everybody putting everything on social media, like, oh, I'm here.
Yeah.
I'm having mental breakdowns, but I'm here at the beach or whatever. I don't know.
Yeah, kind of foolish. All the posting, if you're able to see that stuff, great. I wouldn't ask anyone to friend you on Facebook. I don't think that's a good idea. I think you could see things that would alert you that someone has a disability, for instance, that they haven't disclosed. And then they say, later, you saw me on Facebook. You're my friend on Facebook. You saw that I have a disabling condition, yet you let me go. And that's disability discrimination. So social media has a lot of ramifications, and that's a whole nother presentation. But people are dumb. People are dumb about doing things that people can witness or they put online.
Yep. Again, all the fun things that we have to think about. All right, so now we kind of have an idea of what the reasons are. So for how long? How long are we gonna have to deal with this? And this is the part that I think as business people, we're talking about continuity of operations here. You're like, okay, how long are we gonna have to get someone doing 2 jobs to cover for someone being out? That is my biggest concern with this. And the issue really kind of that I have with the haste that this law was put into place is that the monetary piece is one thing. Okay, yes, is this gonna cost us as employers and employees? Yes, it is. The issue with this is living the 12 weeks and we've all been in this position where so-and-so has to be out for a little while. We're all small businesses. We all do a ton. We don't have these huge departments behind us that we can cover for people while they're out. It's productivity. So, you know, like especially when you have someone maybe that's gone out on maternity leave, obviously you have time, most of the time you have time to prepare for that. It takes you 4 weeks to get someone on board, not even 4 weeks is generous. 2 months, 3 months to get someone on board and comfortable with the job. Then they're working through that. And it's almost like, oh my gosh, by the time someone goes out, if it is a short notice, you're like, by the time the person comes back, the person that was filling their spot, they're like just now up to speed. And that was this whole thing that I tried to, and I got in late on this because I actually was out on maternity leave starting in December. But when this was all going through in Dover, that was my biggest gripe for this, because they ran this campaign and trust me, I like the fact that you can bond with a child and have this benefit. And their thought for this is going to help employers retain employees. This is a benefit for them. This is wonderful. This should help you. We're helping you. We're doing you this favor. But what they don't understand is this whole thing for how long, and our operational minds as small business owners and people who have to deal with this is the ramifications that they didn't really take into account. And unfortunately now we're left to kind of deal with it, but at least now we can start thinking like, okay, are we gonna have a staffing agency on a temp agency on hand for something like this? Are we gonna have a floater in departments maybe? You know, it's just, we gotta start getting creative for how we're gonna be able to address this. Because for parental leave, it's a maximum to be out for 12 weeks in an application year. Family caregiving and medical is a maximum 6 weeks in any 24-month period.
So the parental leave can be intermittent as well?
It can, yes. So we'll talk about that intermittent. Yeah, actually, Catherine, let's go there. Let's talk about intermittent, because this one I think is the hardest for us to track. I have a chronic migraine condition that's keeping me from working, and someone calls you, they call you the morning of, and it's like, oh no, I'm just gonna take my intermittent FMLA. So let's talk about this.
Right. So let me just back up a second though and say, I totally agree with you about covering in advance. I recommend cross-training as well. Go ahead and train people for 2 positions if you possibly can. Have them closely observe, have them track, follow the person, shadow them, whatever it might be. And then also I just wanted to say that I'm on the employer advocacy committee. I chaired it last year at the State Chamber of Commerce. And this bill started as no one's exempt. Everyone, 1 employee and up is included. So we made a lot of noise, and, they are well aware of our objections. They're well aware of all of this because, for one, we were only one entity, but the Chamber of Commerce was up in arms, screaming, lobbying, trying to stand up for the business owners who are really going to have a hard time with the length of absence and even the intermittent aspects. So I think if anyone, please, if they're interested if you're interested in joining the chamber just for that purpose, just to have a say in the lobbying, and we are successful in a lot of cases, right? Then please contact me. And if you're already a member of the chamber, then please attend the employer advocacy committee meetings. You're welcome. Any business owner or HR person or officer, whatever, is welcome. Just let me know and I will connect you to I'll connect you to the chamber to get you on the committee. Intermittently is interesting, like you said, Maria. It's sometimes an unusual condition, like you're saying, like migraines, like something that comes and goes, but it's a permanent condition. They've had it for years. They consider it permanent, right? So it's really tricky to track that. That's what's tricky about it, I think, is 2 days here, 2 days there, and they can only have 12 weeks in the 12-month period, right? And of course, if they go somehow below the 1,250 hours for that period, they're also become ineligible. It's kind of crazy. Maria, I'm sure you noticed that it says that employees, employees can do, are eligible for this if it is predicted that they will meet these requirements. Did you notice that, Maria? It's like, it's not only did they meet it, it's like, are they reasonably expected to meet the requirement of 1,250 hours in 12 months? I just had to throw that in because I think it's crazy. I think it's absolutely crazy. But in the context of intermittent leave, you have to watch that. You have to track the time. It's really, really a pain. Administratively, it's really a pain. And as far as parental goes, that's a harder case to make. It really is, you need to recover from the birth if you're the mom, right? And that's not going to take you 6 weeks, and then you go out another 3 weeks to recover. If it is an ordinary situation, right? You're going to recover in 10 weeks or 8 weeks or what have you, and then not need more time later to recover from the birth. However, there's the bonding, and then it's, well, how long do you need to bond? And that's a lot more nebulous, the parental leave, to me, than a medical condition which recurs. So. Question 2, Maria, do you know whether it's going to be allowed for both parents to take leave if they work for the same employer? That's true, isn't it?
Yes, so both parents can, but it's together. You cannot take more than 12 weeks. So mom and dad both work for the company, or mom and mom, or dad and dad both work for the company. Together, they cannot take more than 12 weeks, and however they choose to split it up. And I believe that is in there, and I can certainly help, and I have a link at the end of this presentation to where this bill actually is, and can help you kind of break down where that actually says that. Looking at this stuff, I've read this thing so many times. All right. So the other thing too, and again, I like to bring out these little administrative details in this, because again, we're the ones affects us. And employers have 5 days to approve an application. Catherine, I thought that was a little too fast.
That's awfully fast. That's awfully fast. It's faster than the federal law. Yeah, that's really, really quick, because you might have to look at this doctor's note and not be able to really tell, is that correct? Is that actually good enough proof? And then send it back to the doctor for more detail, et cetera, et cetera. I think that's why the FMLA federal law it allows you more time than 5 days. Do we think anyone is going to complain that it took you more than 5 days to approve? I do not. I think as long as you start counting the time from when the person goes out, that's going to apply to the 12 weeks, which you really should. You should start tracking it then, even if it isn't approved, okay? Because either you're going to have them fall under your leave policy, whether it's paid or unpaid, or it's going to apply towards this 12 weeks. And that means you are going to be able to say, all right, you've already used a week, right? Well, now we have 11 weeks to go. So I don't think employees are going to have a problem with 5 days to approve. Honestly, there's really no difference. So try to comply. If you don't, I don't see anyone filing suit over this. Certainly the state of Delaware is going to be overwhelmed with this administratively. I mean, they have had to, in order to implement this, to support this, they have had to hire, I don't know, something like 60 people and create a new division at the DOL. I mean, they are not going to have time to be on your back about 5 days. Just, there's no way. So, yeah.
There's always one. But what I was gonna say, business days, 5 business days, it does say that. So at least that helps us. If we get it on a Thursday, at least we have until the following week to figure it out. But I was looking for I was gonna try and read to you all the section of 2 parents, but I'll find that. We'll keep moving on here. To the next
I have one quick question. When they mean 12 weeks, is that 7 days in a week or 5 days in a week?
Okay, regular working hours, Catherine. You wanna take
Yes.
that?
Yeah, exactly. I mean, if the person works, Monday through Sunday every week because they're salaried, that's their regular working hours could be longer, it could be 7 days, Probably not. Probably a salary person, you should consider them as 5 working days, as well as somebody who works, just 5 days, 9 to 5 for you guys. If they are, if they're part-time, then that's considered a working week. They only work 3 days a week. Okay, well, then that's their week towards the 12. Does that answer the question?
So you're saying you go back and take an average of their previous experience in their work weeks, and then that would be considered their work week?
Yeah,
That's right.
regular working hours. And that's another thing, again, not to go down too much of these HR rabbit holes, but I recommend, and Catherine, please let me know if you agree, just establishing people's regular working hours to the best of our ability. I understand that there can be people who, there are emergency on-call people or whatever the case may be, so they're really all over the place. But establishing as much as we can, like if you do have a night supervisor or somebody who works the weekends, like what's their regular working week? And this is all kind of Fair Labor Standards Act stuff, wage and hour stuff.
Yeah, I agreed. You should kind of know that, because you should, if they're hourly, you should be tracking the time anyway. And then you just look back at the records, right? That's easy for someone who's a non-exempt.
So if you have somebody that's working 60 hours a week, not worried about I understand the 1250 to see if they qualify, but after that, they're out for, based on weeks, 12 weeks or 6 weeks, are you paying them 60 hours a week?
Are they exempt or non-exempt?
No,
Meaning like, are they an hourly employee?
hourly.
No, that would be,
And do you have to pay overtime?
right, no, I think overtime is exempt from that. Well,
Correct.
because here's the other thing too, and we'll get to this in the slides. It's the wages that people are earning are capped at $900 per week that people are earning.
Right.
It's the contribution, so the contribution that we're taking from paychecks, which I think it might actually be on the next slide. That's
Right,
one
right.
thing, and then what people get paid is capped at $900 a week. But yeah, and that is a whole other discussion too of, do we have everybody classified appropriately? Exempt, non-exempt, hourly, salary, those types of things. Just again, like another, not to make you walk away with all of these to-do lists and action items to clean up your HR house, but these are just things that I think about when these laws come into effect.
So this would run concurrently with FMLA.
Correct.
Correct.
Yes,
So-
federal FMLA. So they're not stacking 12 federal FMLA. Oh, and then I get my short-term disability and then this, no, it's
Right.
concurrently.
Within a 1-year period. So if someone has already taken the 12 weeks of leave under FMLA, they would not be eligible for this later in the year.
Correct.
Mhm.
And there's the one in the family caregiving, 24-month period. Correct? And that's where, again, this stuff gets very confusing with the way that they worded this, because you got different levels of employer eligibility and then the different reasons. Okay, 12 weeks, 6 weeks. Sometimes I feel like we need like a flow chart or something.
Yeah, that's what I was thinking.
Yeah, that's
Spreadsheet.
Yes.
That's so confusing. I
Yes,
agree.
no.
That's so confusing. That's so badly drafted. Ugh. How are you going to administer? That's so much harder to administer, right, Maria?
Yes,
Mhm.
and that's another thing, and Catherine, you being involved with all of this, and thank you so much for kind of lobbying that you've been doing on behalf of employers as we're trying to work through this, because it's just frustrating. We sometimes just feel like they don't understand and they don't get it, but I believe that this bill was like a national something, like the language of the bill, I think was a plug and play, was like a template, national type of thing, that they were like, okay, we'll start with this. And then, right? Because it was like an advocacy group.
Correct. This is what we should do. And then the states which have adopted it have, pretty closely followed the same route, with the employer contributions and the definitions used under the FMLA and stuff like that. The states are doing that. And I think, yes, you're right. Like a national advocacy group said, this is what it should be. Right. And then states worked from there.
And then there wasn't much adopting for our little state of Delaware, which happens. But and then Helen just put through a question. can they take parental and then family leave in the same year? And I don't believe so. I think it's one or the other. Correct? One
Yeah,
time.
agreed. Agreed. I think that's true.
Oh, also, something else to take into consideration too, when you're writing these policies, I always recommend doing a rolling look back period. Right, Catherine? Because
Yes, agreed. Yes.
you don't want
You don't want
someone-
to start January 1 and then, have it in December 31, because that might, first of all, might not comply with the law. Probably, that's the number one. It might not comply with the law. You have to look back the 12 months, not the calendar year.
Yep. So does that make sense?
Yep.
Sorry. So I think the next one, I have the actual amounts. Okay, so how much are employees paid? Because again, this is what we want to know. We want them, of course, to be incentivized to come back to work. So it can't be too much that they get paid, but it needs to be something livable that when they aren't working and taking care of a family, that can be helpful. So the biggest thing here, first payment must be made within 30 days after the claim is approved. So that's not going to be too much of an issue, you don't think, but we're still dealing with how the state plan is going to work. And if you're doing a private plan, whether the carriers usually are pretty good about these processing payments, disability payments, things like that.
So if
Again,
the state is paying them, the money's gonna come from the state.
correct, if you are a part
If
of the
we are
state
part
plan.
of the state plan, and if it's a private plan, it will come from us.
It depends.
Private plan.
Yeah, it depends on, yes, either the carrier or from you. And then payments must then be made every 2 weeks. So that, I also thought that that was interesting because, and I think a lot of folks, especially in the construction industry, might do weekly pays. So, and that's common, but what about if your regular payroll is monthly? I mean, it has to, the law says every 2 weeks, so we might.
You have to change your payroll practice, which is another very big inconvenience of this law, the way it's drafted, right?
And not to get into the nitty gritty details of that, but it's like, okay, if it's bi-monthly, are we gonna get pinged because it's bi-monthly? That's not technically every 2 weeks?
Oh, Lord.
Honestly, I don't know.
You know what? My practical advice is if you're semi-monthly, just leave it as semi-monthly. I mean, who's going to complain that they're being paid on different schedule than they're used to? Like, no, zero, unless you have a really, really big troublemaker in your company. You're just really not going to have that problem. And if you need to, you can, separately process somebody's if they do complain about 2 weeks, and then they won't have a lawsuit, a cause of action, because you've taken care of the problem. That makes sense.
And then the amount, 80% of the covered individuals' average weekly wages. So that's where you get into, okay, if they are working overtime, what is that gonna look like? But round it up to the nearest dollar during the 12 months preceding their application. So that's again why, let's start tracking some of this stuff now. If you do have variable hour to that degree, or any variable hour really, because this is one of my other action items for this later is, we're gonna have to start thinking about what this is gonna cost you as an employer, what this is gonna look like, because it's a payroll deduction. So kind of, and you're never gonna know exactly, but ballpark, okay, if someone is a variable hour, how many hours do they work in a year technically, for the last 12 years? If they're a lower wage earner, obviously this is gonna be a big deal because some people are gonna wanna know, what am I getting paid, But it is capped at $900 per week, and that's through 2027, and it will increase with the consumer price index, so. Let's see what that looks like. But I do think it's interesting that most of what they're gonna do is gonna be determined by the preceding 12-month period. Sometimes we see preceding 6 months, but it's gonna be the preceding 12 months. So start tracking variable hour stuff now, multi-state employees, all that type of stuff. Question? Yeah.
So you're saying that your look back period is 12 months preceding when they're putting in the claim. So we're not really factoring how many hours in a year. At that point, it's really the 12-month period.
Right, Catherine? I mean, that would be.
Yeah, that's right. You have to go back. But if you're someone with variable hours, they should be, it should be in your system, right? They should be clocking in and out. So you should be able to look at your system and then just figure out the average based on that for the last 12 months.
Yeah, and that's where, and again, I know sometimes it's, well, we're cleaning up systems and we're not tracking appropriately or moving from paper to digital. I'm just saying for now, as we know, okay, it's gonna be 12-month look back period. Let's start getting in the habit of tracking this stuff now so we can work out any kinks in our tracking system, payroll system, or spreadsheet or whatever we're using. Just so when we're faced with this in the next 2 to 3 years, that we're not like, oh my gosh, now what do I do? And I have to account for this a year prior, start doing it now. That's just my
Because the
recommendation.
effect of that is like for us, if we have a higher wage time in the summers and they're hitting it in the summers, we're
Yeah,
now collecting 2 summers, which the wages are higher and the hours are more.
yes,
Versus 2 years,
Yeah.
I mean, a year, which your January through March
right,
might not be as high
yeah,
in that case.
yep.
Yep,
That's-
could
that's
be.
a- That's a very good point. Very good
Could
point.
be. And if you're looking at 24-month period, that's the same. Yeah, could be 3 summers, right? It depends when the person was working for you in the previous 24 months. I have a horror story for you guys. So forget about complying with this for a minute, because, this, okay, let's just put that aside for a moment, all right? Because we have some time to figure this out. I have a horror story about not tracking time. Okay, so we were, I represent people defending these things all the time, but this is my best story about it is the Department of Labor came after our client for failure to pay $3.4 million over a 9-year period. Okay, craziness. We actually did the calculation for the client, and it was $125,000 that were owed. These were all Fair Labor Standards Act allegations, right? And the tracking hadn't been done correctly. The hours hadn't been recorded. The DOL takes the word of the employee. They don't even have to write it down themselves. But if they do write it down, they credit their version of things if you haven't written it down, if the employer hasn't written it down. So we said, look, the business will pay $125,000. And they said, no. They had court-ordered mediation. This was in Philadelphia, the federal court. And they came to mediation and said, we're not authorized to settle this for anything less than $3.4 million. That was not good faith, let's be honest, right? But they're not paying their attorneys. They have people on staff. They're not paying them hourly. It doesn't work like that for them. So they can take whatever position they want. We went to court. We had to, because the company would have had to declare bankruptcy if they were just say, okay, fine, we'll pay $3.4 million, right? So we did that. And the judge, it was only a trial with a judge. There was no jury. The judge determined that our client owed $125,000. Okay, so sorry, but I can't overemphasize the importance of tracking hours, doing your own tracking and not letting someone else track, because this is like the nightmare scenario. You want to do this beforehand. You want to make the effort, put it in, because you do not want to pay me $100 zillion. I'm not even going to say $100,000. I'm going to say a lot of more money. It can be a lot of money, depending on how stubborn the DOL is. So I would love to help you in that situation, but my best advice is to get it covered before, not just for purposes of this act, but for lots of reasons.
Yeah, and that's, something, if you're advocating to your business owners or your leadership, like, hey, we really need to take the time to do this project, to clean this stuff up. Now's the time to do it, because we don't want to be doing it scrambling in the year 2024, getting ready for contributions to start coming out and people start going out on leave in 2025. Because what is my cost as an employer? So this fund, this state fund, or whatever other fund that we're talking about, is funded by payroll contributions starting in 2025. So Catherine, that was another thing that I wanted to confirm. The contribution, so money's gonna start coming out of paychecks in 2025, and when does benefits start getting paid?
Right, it's the contributions just start in 2025. That's right. And that's when the employer starts having to to pay in their contribution, right?
Okay, so when can employees start taking this?
I think they can take it as soon as they want, depending, if they think they've built up enough money that will help them with their purposes, maybe they haven't made, won't make $900 a week. But if they say, well, I have no choice, I've only contributed and my employer's only contributed enough to get me paid $400 a week. Okay, if they want to take it, then they can take it whenever they want to. Yeah.
So that's another thing that we want to start, because we want to make sure that the fund, I believe the contributions are going to start before people are allowed or permitted to take leave, but let me confirm that.
2026.
2026 that
I
they
think
can
the-
start going
the
out.
Previous one said 26, 27 as far as the funds.
26,
going out.
that's right, okay, yes.
Yeah.
So, let's see, I'm gonna reread the bill here too.
Yeah, I'll take another look at that, because it might be that year, is when they can get 900. Anyway, yeah, I'll take another look. Sorry about that. I can follow up with you guys if you want.
Yep. Just saying, yeah, because that's what our employees are gonna wanna know. And I'll tell you,
Sure.
a lot of folks are just like, no, we don't have to worry about that now. We don't have to worry about that now. Well, the stuff comes quickly.
So you're saying distribution from this fund is based on contribution levels?
No, it is going to be based on the employee's average earnings. But the contribution, again, is this percentage amount.
Of their average earnings.
Correct. Of their pay. Now, and that's why they went with the percentage, because they're thinking variable hour people. And this is where, again, that it gets tricky, because not everybody in their workforce is salaried and they get paid $40,000 a year, period. That's where it's gonna be hard to determine these costs, because it's 0.8% total. The employee pays half, the employer pays half. And that's how they break up the percentages, because they're thinking, okay, 0.4% goes to medical leave, 0.08 is family caregiving, and parental leave is 0.32 for a total of 0.8. So we're thinking 0.4 for employees, 0.4 for employers off of average
Percentage
earnings.
of their average pay.
Correct. And that's per paycheck.
That's just taken out, it's not an average, it's just taken out per paycheck. Whatever their pay is, my understanding is you just take out, you pay 0.4 and they pay half and you pay half, and the total is 8. Yeah, you're just withholding you're just doing that every paycheck.
Right, and that's where you kind of liken it to other payroll deductions. I mean, 401k is
Right.
the biggest one, is because that's percentage wise, rather than a set dollar amount. So you're gonna put in and I'm sure if you outsource your payroll, ADP, Paylocity, Paychex, whatever, you're gonna have a code for this, because other states do this, and you'll be able to set the percentage, so you won't have to track that every paycheck. But again, this is what we're talking about, 0.8%. And again, that's the employee pays half and then the employer pays half.
If you have an employee that primarily works in Delaware, we're in Pennsylvania, by the way, so we just have a smaller crew that usually works in the Delaware area. If they work in Delaware, say 30 hours a week and 10 hours a week, they're in Pennsylvania at a different job, is that contribution out of the full paycheck or just the jobs that are in Delaware? It gets real.
Yeah.
I think the payroll deductions, the contributions to this insurance fund are applied to people primarily employed in Delaware. And again, we don't know what that definition is, but it's going to be the whole paycheck. It's going to be 0.8% from the whole paycheck if the person is primarily employed in Delaware. And in my opinion, which this has not been regulated, it's more than 50% if they're in Delaware, then they're eligible. This is it.
Okay, so even
The
if
whole
some of
paycheck.
their hours are Pennsylvania, it would still be
Yeah.
that week.
Yep.
Yes, it wouldn't
Yep.
be the 30 hours just in Delaware, it would be full.
Which means depending on other state laws, you could pay multiple states into this fund. So the requirement for Maryland is 600 and some hours. You can meet the 600 and some hours and the 1200 and some hours. And possibly, depending on if they use the same language or not, primarily in that state. If they eliminate that line and just make the requirement a certain hour, you could end up paying 2 states.
Right.
Where do you
Right.
pay- Who do you pay unemployment to? Do you pay multiple unemployments, or are you primarily paying Delaware unemployment?
We pay.
Yeah, unemployment is based on where the person works most of the time. So,
It normally follows what,
Right,
where the unemployment is.
Right,
Where
and
the
I think-
company's located.
Right.
we're gonna definitely see down the line here, like especially if you have the Maryland and the Delaware employee, what this is gonna look like. That remains to be seen. How we're, someone goes out, what do we, and especially if you're using the state funds.
yeah,
which
you just have to determine where someone primarily works, and then you either comply with Maryland or you comply with Delaware. That's it.
And then I'm not gonna lie, I have very strong feelings about using state fund versus using private plan. Obviously, I'm a benefits person, I'm a benefits broker, so, but at the same time, I just am not sure how well this is gonna be managed and administered on the state level. And Catherine, I feel like that remains to be seen as we develop this whole department that they're doing for this. But before we get there, I just wanna highlight what's my cost as an employer. We kind of already are working through this, but employers must make their contributions to the fund at the same time the employee's wages are deducted. And then if the employer fails, so this is, again, it's kind of the same thing as 401k, right? You take the money out, the money goes right to the 401k account. Take the money out, goes right to the state fund or right to the leaf fund. If the employer fails to take the deduction from the employee's paycheck, so again, this is another administrative thing. This happens all the time for us as HR people. Oh my gosh, someone elected short-term disability and I didn't catch it and they've been on it for 3 months and I haven't collected their funds. Now I gotta go back 3 months. That's 6 paychecks, $10 a paycheck, $60 they owe me, I'm gonna take it out. If you fail to do that, if you make that same mistake, as we all know it happens all the time, you still as the employer you are liable for the full contribution to the fund still. So
Maria, does this start when they become employed for you or when they get qualified?
I believe it starts from day one, right?
Yeah.
Catherine?
Yes, I think, I believe so. Yeah.
Yeah,
And,
so at least you don't have to worry about an eligibility to track.
So they're paying for this even.
But
if they're
it
not-
says they have to be working for 12 months,
Yes, but they can start contributing to the fund as soon as they're hired.
but they can't access it. for 12
Correct,
months.
correct.
But
because-
if they quit, what happens to that money?
So it just, it's in the fund. Yeah, that's kind of how they're gonna build up the fund.
And the
That's the
employee
big
just
plan.
keeps their percentage?
Right. They keep what's already in the fund and then they move on to another job and start contributing to the fund again.
Is that designated like unemployment when you're putting it in? Is it going by a social security number? So it's tracked to their fund or it's just a fund?
No, I
I don't know.
Yeah, that's a good question.
That's a regulation, I think, to come, and the division has to figure that out, and they're way behind, and hopefully they catch up and figure it out and tell us.
So then the second question to that is, so we're depositing this, if we pay weekly, if you'll keep weekly. If we're paying weekly, we deposit weekly, so it's not like a quarterly report. It's done as of.
Correct. Correct. Yep.
They have a portal, I assume, that's getting deposited to?
That is so also on the state.
They haven't figured that out yet either.
They have everything, so this is the fiscal note where they break down the costs that, and you can kind of glean from this. There's something like $200,000 to add a payroll and tax module to the integrated revenue administration system, collection system. So they have this plan and do read through this stuff, but
So we'll get a link to the plan or something,
likely.
maybe?
Yes,
I would guess it would go into the state portal now that they
Yeah.
have that.
yes, that would be the thought. So would just be one other thing for people who process payroll that, okay, now I have to allocate these deductions here.
It's part-time employees contributing to, just in case they go?
Yes, yes, part-time employees are contributing, right, Catherine?
It's never going.
Yeah, because they might add up to 1250. It's, as we discussed before, that's not many hours in a year, honestly.
it's not a lot of hours, but then they might actually be contributing, but not be able to take advantage of it.
That's right. That's right. And then they would just carry it into the future.
Who comes up with this stuff?
Your legislature.
So a lot of things remain to be seen, but again, I just want to, oh, hold on. I accidentally clicked. Stop.
These people have no intelligence.
Someone's, okay,
Yeah, the chamber did this calculation of how much it was going to cost the state and actually presented that breakdown based on what we knew the administrative cost would be and the cost of, if you see this cost allocation that the legislature actually put out there, you can see they even had to hire attorneys general. They're going to have to hire deputy attorneys general to make this work. It's crazy. So we gave them this huge breakdown of like how much it was probably going to cost them. And in fact, they did come up with a huge cost. It's millions and millions and millions of dollars, but yet they feel that this public policy interest is best served and that it will encourage people to work in Delaware instead of working in other states, which we do want. We do want that.
so, and this is a good question Karen put through. If a new employee has bank time from a previous employer, how are we supposed to know how much to pay based on hours up to the, okay, so, all right. That $900 limit is going to be what they receive if they take advantage of the benefit. What you're paying is a percentage. So that is correct. You base the payment to the fund on hours worked because it's that 0.8%. And then it's our responsibility to delve out, okay, 0.4 is from the employee's wages, 0.4 is for the employer. Does that make sense?
What if a person was on another private plan? How would you know what they had?
So if they were on a private plan, oh, that's a good question. Catherine, what if an employee goes from an employer that had a private plan and then goes to an employer who's taking part of the public plan?
Yeah, I mean, they wouldn't have been contributing, right? If they had a private plan, they wouldn't need to contribute. And you, Maria, are going to go over the the qualifications for a private plan, which would exempt people from having to do this item on their payroll every pay period.
Okay, so let's talk about that. And I apologize, I'm just getting this guy back up. I may not do the presentation just because I'm not sure. I don't trust myself.
Here we go. No, it's working now. Here we go.
Okay.
He's advanced. We're advancing it. Okay, there we go. That's the right slide.
Let's talk about this private plan. And again, it's going to be hard to figure out now with this employee who comes to you and how people are moving from employer to employer in the state of Delaware. But we're talking about a private plan. Yes, something that should be administered or can be administered through your broker, and to talk to them about it. Start preparing for it now. I know we're in talks with some of the major carriers because again, this stuff happens in other states. In fact, New York disability policy is something that we administer. We use carriers like the Hartford. There's Equity. There's another carrier that we use. And in New York, those folks, you have the private plan, you set it up, and it's all the administration is taken care of by the carrier. The employee, just like you would normally on a disability claim, they fill out their paperwork, they send it to their doctor, and it all gets submitted, and the carrier either approves or denies. Without knowing what, and again, I'm biased, but also without knowing what this whole state fund is going to look like. Also, I may be a little bit of a control freak. I don't know. I like to know these things, and for us to know where the dollars are going, what's being administered. I like having a private plan for that simple fact. let the carriers deal with it, let them handle a lot of the liability, the administering, the payments. And you set up your private plan that, okay, employees you'll still deduct deductions from their paychecks, but you're sending it to the carriers. And as long as your private plan meets all of the eligibility of the state program and you have all the different provisions, yes, the people can take leave for these reasons. Yes, we offer this. If you want to offer more weeks of pay, you know, some of our large employers offer 16 weeks or whatever it is. Provided the cost to the employees is not greater than the state plan, that's fine. And then provided that there's an internal administrative review process, a notice, appeal process, all that type of stuff. So you can mirror this state plan in a private plan. And that's what now I'm trying to talk to the carriers about this. That's like, listen, my clients don't want to have to worry about this. We want to be able to say, oh, we have all of our life and disability coverages through MetLife, through Principal, through Unum, through Mutual of Omaha. I want a rider on the plan that we pay, okay, the premium's gonna increase by, I don't know, whatever, $5,000 a year, $20,000 per year, whatever it is. And I want peace of mind knowing that I had that rider, the broker and the insurance company take care of it, and then I don't have to worry about
We will have to pay for that plan.
it. Correct. The employer would have to pay for that plan. So start thinking about that now. I can tell you right now, the carriers are very annoyed at me because I'm like, I need to know, I need to start moving on this. And they're like, we have time. We have plenty of time. And I'm like, yeah, but I have a ton of clients in Delaware and in Maryland who are not very happy about this and need to know and start planning now. So I'm on them to get something established. I'm working with some general agents now who do a lot of work with New Jersey and New York, who already administer this stuff. So I do want to call attention to that real quick. New Jersey, family leave insurance, that is a state fund. So they do it and you have to use the state fund. But in New York, you can use a state fund or you can do a private policy. And I have a lot of clients who do a private policy. So this is being done already, and we're in talks with some of the general agents and the carriers who have experience with administering this with clients in those states.
So is the state charging you to use their fund? To contribute into the fund and have them take care of it?
In New Jersey. So that's
No, in Delaware.
Catherine, actually, that was something that you and I had talked about before this. The state's not charging us to use their plan, right? Or are they?
I believe not. I believe it's like unemployment. You just pay in and they handle it, right?
So, yes.
Can I ask another question? Can you?
Sure.
You hear me? Sorry. Back to the other question about the an employee that has bank time from a previous employer. What I was referring to was, so if he's working not as many hours for us as he was there, how do we determine how much we're supposed to be paying him if he's already paid in from a previous employer? I don't know, because it's a cap of 900, but if he had averaged more hours there than what he's averaged for us, we might underpay him because we're not taking into consideration the hours that was contributed into that fund. Or doesn't that matter? He just has the money there.
I can take that. He just has the money there, and it really doesn't matter. That if you go through the state, they will know how much is there. They'll have the fund, right? I assume if you go through a private carrier, they will look at that too and know how much is there and tell you how much you can, you're supposed to pay out. Is that right, Maria? I haven't been dealing with, the private brokers.
Yeah, but also don't forget too, though, that you can still, if this is a new employee, if they haven't been with you for 12 months, you're going to deny the leave. You're
Right.
going to say, sorry.
Correct.
It doesn't matter that you worked for so-and-so company.
Okay, that makes sense. Thank you. Thank you.
Yep, and this is where, and I understand it gets a little confusing thinking about contributions that the employees are making versus what they're going to be paid out from the fund. So obviously two separate things. And if they're not working for you for 12 months, then you say, I'm sorry, you're not eligible, and you have to decide whether you're gonna continue to work for us, or you're gonna take the leave unpaid if you allow that, and then you have all these other problems of you're gonna continue their health insurance, you know, all that type of stuff. If you wanna do non-FMLA leave of
So
absence.
it's not like a look back period that the employee has.
Correct. It's not a look back period for other employers. Yeah.
It's just you.
Yeah.
So I have a question. This is Joanne McCluskey, remote. So Catherine, you said that the deductions kind of work like unemployment per se. You're kind of paying into that state fund. I guess what I'm hearing is the difference is if an employee goes out on unemployment, unemployment pays them. But if an employee goes out on this leave, the employer pays them, not the state. So like.
Depending, that depends on if they use the state fund or if you use an employer private plan.
So if we use the state fund, then the state pays them.
Yep. The
So
state.
that's like in New Jersey, the family leave in New Jersey, they file and New Jersey pays them. The
Correct.
employer is not issuing them a weekly check.
Correct.
Okay.
Correct. And that's where I would even, again, thinking about this from a practical perspective, I don't recommend self-administering a private plan. An employer plan. It's either state fund or you're going to the carriers to do it. Quite honestly, I think that's our two choices. I don't know how much the carriers are gonna charge in premium for this though. Like, let's be honest. Yes, I'm advocating, yeah, we can do a private plan and you should really consider that, but I don't know what the premiums are gonna look like. But that's what we need to start getting some information about. And of course, they base carriers rate premiums off of your census data. So they're gonna look at how many people do you have that are of childbearing age? How many older folks do you have? How many seasoned? We're not allowed to say old in HR, right? Seasoned, sorry. But these are the types of things. So that's how, I can't tell you, oh yeah, it's only gonna cost you $5,000 to do this plan with Mutual of Omaha. They are the ones who set this stuff. So it's all based off of census data.
I don't remember. No.
Yeah, I was gonna say, do you remember now?
There was something earlier that said, is there opt-out option?
Okay,
Because
so,
like, does every employer, like, I'm past my childbearing years and I'm an orphan, so I'm not gonna be taking care of my parents. So
Yeah.
can I opt out of this program?
no, right, Catherine, no individual
No.
opt-out.
No, because they think you could always contribute for your own serious medical condition, right? And so the 0.08% would go to that. It would go to that,
But is there, like, I own the company,
right?
so can I opt out because of that? Like I can workman's comp?
I think it's both. I think you get workers' comp and you can use this both. And the owner, I think, counts as an employee. And so you would be included in the count. And of course, you would have had to work 1250 for the last 12 months, blah, blah, blah. You have to, I assume you would work 1250. That's not really a question.
Yesterday, yeah.
The other thing, and I have opt-out, when I say, I think with the language in the plan or in the law for opt-out is meaning you can opt out of the state fund for your
Right.
private plan. But employees themselves cannot, nobody's safe. Nobody's exempt from this. Right? Right?
All right, this together.
Okay, the other thing too, again, and this is if you do have a ton of employees, I know HR departments run thin right now, but one of the other things, I have some other clients that are looking at outsourcing their absence management period. So it's something you might want to look into. I have clients now who have that, and that's a tag on like through Principal or whatever, and it's $4 per employee per month, and that's the other thing is with these costs, talking about how the carriers rate this. I'm not sure, is it gonna be a per employee per month cost, as oftentimes a lot of this stuff is in benefits, but just start thinking about that. Also, to make this even more complicated, this private plan versus state plan, it says a hybrid arrangement is also permitted. And in my mind, Catherine, I would think that would mean like, okay, you use the state fund for, let's say, parental leave maybe, and you use a private fund for medical, I don't know, but that is.
Because they did have different percentages in
Yeah.
each one of the categories.
Yeah, so to make it even more complicated for how you're tracking percentages coming out of people's paychecks. Oh yeah, we're gonna use the state fund for the parental leave provision, and maybe we'll use a private plan for FMLA or vice versa. Actually, yeah. So now I'm thinking about that. That you would use a private, in my opinion, you'd use a private plan for the employee's medical condition, and then you use the state fund for parental leave, other type of stuff. Anyway, we could go down a whole thing with that.
Yeah. Maria, I think they're gonna regulate that. I mean, that's really complicated, don't you think? I mean, that seems to me like, yeah, they'll tell us.
Well, let's see, that remains to be seen of what this hybrid plan.
And you said this is coded, so like your payroll company will take the money out and also make the payments?
So that's the part I don't know yet. I'm assuming they will, because I believe that they do that for other states, and they claim, oh, we take care of that for you.
Thank you.
But that would be another action item. Talk to your payroll.
Because if we do in-house payroll, then we're gonna be responsible for making all these payments.
Yes, correct.
Right.
If our company is only gonna have to pay parental leave, are we still going to have to take the money out for everything? For the family caregiving, the parental, for all the items will be taken out, or we only have to take out the percentage for what we're gonna have to pay?
That's an excellent question. So you're under 24 employees?
So are we gonna have to pay everything?
I think it's, I agree, that's a good question. I don't know the answer looking at the act. And I don't really want to predict and give you the wrong answer. So again, the answer is, we can let you know when the regulations come out. And then we can give another presentation about, okay, this is what it really says. This is how it's really going to be run. And again, that will not be until 2023, but you can watch for, some kind of announcement that Maria and I will speak again, maybe, right, Maria?
Yeah. I love doing this stuff. This is fun. I enjoy talking through this. We got one more chat to confirm that employer's payroll is only responsible for depositing the employees' contributions into the fund. Correct. No, your employer contributions as well.
You're gonna have to do both.
Yeah, both your
Right.
employer and employees' contributions. So that 0.8, you just have to make sure that 0.8% of everybody's earnings is going into that fund. And then we have to.
Well, 0.4 you and 0.4 them.
Yes.
But is it going to be that if we don't have to pay the
Correct.
whole pond?
Yes, we don't, remains to be seen. I not pay the employee, correct, when you're not giving the employee their payouts, their benefit, we'll call it their benefit, while they're out on leave, if you're using the state fund, the state is handling all of that.
I was at a webinar before it was finished with one of the state representatives. And she was talking about if your company wanted to, they could pay the whole thing and the employee didn't have to pay anything. So it's that that maximum half for the employee, minimum half for the employer.
Right.
You can change that any way you want.
Yes, if an employer wants to be, and again, I understand, it's like, well, I don't know.
Yes.
If you want to use this as talent and leverage or to gain top talent and leverage of your benefits package, hey, the state requires this we have paid FMLA for you and you don't pay a dime for it. We cover the entire contribution for you. That's one of the things that we can say as part of our benefits package. Again, certain things that you want to look at. As business owners and strategy people, we're trying to project 3 to 5 years in advance. This stuff is important to talk about now because it's going to take you 2 years to get that one over on the CFO and the business owner. Like, oh, this will be so great for talent, yes, but talent acquisition, but it's tough. All right, so I know I kind of gave you a lot of action items here and some things to think about. I hope that this was valuable for everybody. start researching private plan costs versus the state fund costs, which, as we said, we don't think that there's a cost to use the state fund. It's just what's coming out of people's paychecks. But might want to start talking to your consultants and your payroll people, your brokers, all that type of stuff to get prepared. And just start doing the math and the projections and tracking working hours and what their primary state is. We can absolutely start doing that now. And talk to your consultants, call your employment attorneys, call Catherine, call me. I'd love to work with you all in an HR benefits capacity. So I have a bunch of cards here that I'll leave out and we'll love to continue this discussion. So we I think my last slide was neighbor states, which we talked about. So 11 states total have paid family leave. Massachusetts up to 26 weeks, crazy. Maryland coming October 1st. Connecticut has it, like I said, New York, New Jersey. Not going to go into details about that. In this presentation, this is where the bill, the details of the bill and the fiscal note are all on that first link. And then the second link is just the resource for my picture there from Patriot Software, which is an HRIS paper. So I will leave up our contact information here. I appreciate everybody's.
One more quick question, because we're in Pennsylvania, we have about 140 employees, maybe 20 in Delaware.
Okay.
So are we only considering the 20 employees, or we're considering?
I think eligibility, right, Catherine, it would be the entire number.
Yes, it would be all of your head count. And then for those people in Delaware, you need to contribute the 0.08% total. Yeah.
So yeah.
So just the Delaware.
Yep, will be those people
Yes.
that would be the deductions taken out of their paychecks. So yes,
That's right.
unfortunately, you're over 24 and in what you have to comply with the law, but only those 20 folks are gonna have the deductions.
On people whose web addresses, I didn't get those.
Oh, yeah, and we'll send this out. I think Jean's gonna send out the PDF presentation so that you can click through it on an email. So you have all of that. Okay, Catherine, thank you.
Oh, sure, Maria, thank you for doing it with me. Again, if you want, I have an email blog list if you want to contact me. It's a short blog. I usually do it weekly. It's all about employment law for employers. And obviously when this becomes available, when the regulations are issued, there will be a short blog about it. And you will then be aware and you'll be able to look up the regs and then, follow up with any questions to either Maria or to me.
And I'm on Catherine's blog and they're great. I love the emails. And if the topic doesn't apply to you, just mark it red or whatever, but they're not.
Right. Well, and if you don't like it, you can always unsubscribe. Just get rid of it. Yeah.
Catherine, what I love about your blog though is that it's short.
Send them to you.
So we're not writing like pages and pages of this. It's like literally it's a blurb. Does this apply to me? What do I do about it? And then because this is what we want to know. It's like, okay, tell me what I need to know. And then what does that mean for me? What do I need to do about it? And that's how I like to have these discussions. It's like, okay, what's my action item? Because we got enough stuff to worry about. You need someone to help you figure out what the action item is. So that's what we're here for. Cool. Thank you, everybody. Great to see you all.
I don't know if this applies to I'm in the restaurant industry. Okay, so my employees don't even have enough money in their checks because they get paid tips
We'll never.
to pay their taxes already. Now we're putting another thing on.
I have not.
Are you presenting us?
I don't know.
Okay.
Maybe I'll call her and ask her.
You're Steve, that's right.
Steve.
Yeah.
Yes.
You're gonna have to look at his.
Okay.
He has that.
I think it would apply to the tipped wage. I'm getting that a little bit, the question about the restaurant association, or about the restaurant owner. I'm sorry, I can still hear everything. So I get the question for everybody was, what if they're tipped, right? They have a tipped wage, right? Am I right? That's what, yeah. I think you still have to deduct from the tipped wage. They're certainly not going to get much in their account, are they?
Well,
Not much.
they already end up at the end of the year not having enough to pay their obligation to taxes.
Mhm.
Putting another deduction on them.
Are you gonna have to put their?
Yeah, I know. That's rough that's another consideration, right? It doesn't really help some people. It doesn't help some people. Hey, have you tuned into the DRA? I'm active with the DRA. Yeah, and Carrie, Carrie's on top of this. I'm good friends with Carrie, and we work on this stuff together. We'll get information out to you as we become aware. Yeah.
We should definitely try and do, Catherine, that would be great if you want to do another one piece for DRA.
Sure again. Okay. I think we have another question.
Come out of their gross income or their net income?
Gross. All right, thanks, guys. I hope everyone has a good day. If you, again, any follow-up questions for either of us, feel free to email, no charge, free consult. I'm sure Maria gives free consults all the time, just to learn what your business is about.
Thank you, Catherine.
You're welcome.
Just do the private.
Set it on the pride, girl.
I'm retiring. Anybody want to buy some restaurants?
No, do not say that out loud. Now, our group, do not say that.
Good to see you.
We have enough.
Oh, yeah, you know what? I'm gonna make a call. See,
You're not gonna make a call. No.
It's gonna be.
We're actually in a discussion right now to start that. So that goes feasible.
Yeah.
And if you say that happens,
That's interesting. That's interesting. I do a lot of activities, so I'm not yet jumped on this thing.
Yeah.
But that was because you want that in the aggregate. I'm just trying to stop recording.